everyone, and welcome back. Today, we're going to focus on one aspect of the Florida guardianship incapacity procedures, and that's when you have examining committee reports and you have a contested incapacity proceeding. I want to go through the strategy that we employ and other attorneys in the area I've noticed employ for attacking and sometimes defending examining committee reports during these contested hearings. This is, again, I think the vast majority of guardianships aren't contested, so this only comes into play when there's parties that are trying to either, one's trying to have a finding of capacity and one's trying to find have the court find a finding of complete capacity or incapacity. So what we're going to go through, we have a little agenda to go through as always, outlined for you. It makes sense to go back through the basic procedures that the Florida statute provides for determining incapacity, but it's pretty lengthy, and I'm going to go through the statute, but I'm going to skip a lot of parts that I don't think are terribly relevant to our later discussion on strategies for attacking and defending. But I want to highlight what some of the rules say because I think you'll see where it comes into play when we talk about those strategies. Then the second part, we're going to look at examining committee and what they're made up of a little bit closer. What's their role exactly, and what are the legal requirements to appear and to serve on an examining committee? And then we're going to start getting out after we've reviewed all those kind of procedures and we know exactly what the statute and the law requires. We're going to look at some specific issues that sometimes come up about when you're trying to attack or you're trying to defend examination reports, and maybe discuss some strategies on that as well. We're going to take a quick look at motion practice. I think there's some key motions that the law requires, some of which are not really set out by statute, but have became more of a creature of case law, and make you aware of those that relate to examination reports. And then, as always, we'll have our conclusion portion and try to give enough time for some questions to be posed if you have any. So with that, let's jump right in. So, in Florida, a person is incapacitated not simply because of the presence of an illness or condition, but because of an inability to personally accomplish necessary tasks as the result of an underlying illness or condition. Incapacitated person means a person who has been judicially determined to lack the capacity to manage at least some of their property or to meet at least some of the essential health and safety requirements of that person. And I cite the statute there. I reiterate this because oftentimes I think a fundamental mistake that litigants take is, well, there's a report that they have dementia, or there's a report that they have early onset Alzheimer's or cognitive decline or things like that. And they argue that equals capacity almost as a matter of fact or a matter of law, and that's just not so. Forgetfulness is often a sign, especially with those things I just mentioned, especially early on. It's a sign of just aging without an underlying condition or illness. But in and of itself does not mean that the person can't, manage their property or essential health and safety requirements. So I think that's one of the first snap views is don't confuse the underlying illness itself or condition as incapacity per se. Make sure that condition or illness you're relying upon, you can demonstrate how personally to this person they're not able to accomplish necessary tasks for day-to-day living. Okay, so the first steps when someone files a petition determining incapacity, one of the first steps is the court has to appoint an advisor and a court-appointed attorney and someone to read the notice to the AIP, what we call an alleged incapacitated person. But with regards to our discussion today, one of the most important functions of the court is within 5 days after that petition is filed, the court shall appoint an examining committee consisting of 3 members. 1 member must be a psychiatrist or other physician, and the remaining members must be either psychologists, a gerontologist, a psychiatrist, a physician, an advanced practice registered nurse, a licensed social worker, a person with an advanced degree in gerontology from an accredited institution of higher education, or any other person who by knowledge, skill, experience, training, or education may, in the court's discretion, advise the court in the form of an expert opinion. Now, again, this is something we're going to look at later. Is your examining committee member qualified? Unfortunately, or these are hard roles to get filled sometimes. The courts are limited to people who are willing to serve because they serve at a very lowered pay and at a risk of not getting paid at all, depending on how the incapacity proceedings play out and the availability of funds in the local budget. So as you can imagine, there's not always a plethora of people to choose from, and you see people who are in professions that are not on this, enumerated list that the courts have decided to allow to serve in their discretion. I've seen EMTs, I've seen really just caregivers, maybe licensed caregivers or work for accredited agency. I've seen lawyers who are just experienced in these areas serve. You need, if you have some questions about the person's qualifications or ability to do their work, look back at this list and look and see if they meet that definition that the judge can use in his discretion, which is they have some kind of knowledge, skill, experience, training, or education that leads them to be qualified to make an expert opinion on the capacity of a person. Then there's some restrictions about you can't appoint, family physicians and things like that. But I want to add this because this is overlooked so much right here in my experience. If the attending or family physician is available for consultation, the committee must consult with the physician. That's kind of put it there in the middle, it's squeezed in the middle, and I think it's overlooked a lot. I see so many reports where it just says, no, I didn't consult. And reason given, really nothing, no real explanation, just didn't do it. I think, it says must. So unless they're just not available, they retired, they've moved, they won't answer your calls and talk to you. I think that right there, you've missed a check mark, and your examining committee report is suspect or subject to attack. Again, yeah, the usual that you wouldn't have put people that are related or associated with on the committee. You're going to keep them impartial, no conflicts of interest. Okay, again, I'm not going to concentrate on any these things about, not governmental interest, governmental agencies, people that work for government agencies, things like that. I think it's obvious why you're trying to avoid conflict. Um, uh, there is a requirement now that they must complete training, and we'll look a little closer at that later. But basically, there's 4 hours of training required every 2-year period now, and to stay on the list of being regularly appointed, you have to file affidavits and things like that. There is some waiver if you've served for quite a while on that. Okay, this subsection E, I want to read through it because again, I think it's going to come up when we talk about strategies. You should circle subsection E here because I think this is some language here that's mandatory but oftentimes overlooked. So what do we have? It says each member of the examining committee shall examine the person. Again, a shall, and examine the person. In this post-COVID age, I see so many reports where they have not even seen the person in person. They've done a Zoom. And there may sometimes be reason for that if the person's in the hospital or suffering from an illness where they can't make contact with other people. But to have that as a matter of practice, I think you're already skipping the first sentence requirement here that you have to examine the person. Each examining committee member must determine the alleged incapacitated person's ability to exercise the rights specified under the statute listed there, 744.3215. An examining committee member may allow a person to assist in communicating with the alleged incapacitated person when requested by a court-appointed counsel for the alleged incapacitated person. But they shall identify that person who provided assistance and describe the nature and method of assistance provided in his or her report. And this comes into play sometimes when people have suffered strokes or what for whatever reason they're maybe they've come up with some shortcuts to say yes or no. They tap once, tap twice, things like that when they perfectly understand, but for whatever reason their communication skills are limited, and there may be someone who can assist them. There's also times when someone's just much more comfortable having someone sit by them. But again, if they're assisting at all, if they're explaining things, if they're saying, I want this person to explain to you about something, that really, if they allow that, that really needs to be put in the report. In addition to the examination, each examining committee member must have access to and may consider previous examinations of the person, including but not limited to habilitation plans, school records, psychological, psychosocial reports that are voluntarily offered for use by the alleged incapacitated person. And again, I think this, you can rely upon this, that you have access if you call the doctor, things like that, or want to talk to the physician. This is telling that each examining committee member must have access to those kind of things. And if the alleged and if they are voluntarily offered up by the alleged incapacitated person. Each member of the examining committee must file his or her report with the clerk of the court within 15 days after appointment. Okay, subsection F, I circled this one too, because this is another one that I think is can be used oftentimes to attack reports that don't comply. The examination of the alleged incapacitated person must include a comprehensive examination. And that's a word of art, a legal term, and there's case law on it, comprehensive examination. A report of which shall be filed by each examining committee member as part of his or her written report. The comprehensive examination report should be an essential element, but not necessarily the only element used in making a capacity and guardianship decision. The comprehensive examination must include, if indicated, 1, a physical examination. Again, I think that's hard to do by Zoom. 2, a mental health examination. And 3, a functional assessment. If any of these 3 aspects of the examination is not indicated or cannot be accomplished for any reason, written report must explain the reasons for its omissions. Now, if anybody's familiar with these reports, most of them are pretty good, but you will get from time to time reports that are very bare bones, especially when they examine by Zoom, or they just look at prior or someone else's prior medical report that was put in there, that someone supplied them, and just essentially copy and say they just relying upon what that report says. I think if any of those things happen, you have not had a comprehensive examination, and that you have potential problems there. And then we go on subsection G, and we're gonna look at a case that talks about comprehensive examination here in just a minute. So keep that in mind again. To the extent possible, a diagnosis, prognosis, and recommended course of treatment should be in the report. Now, this is going to be hard for non-medical committee members to do. They'll probably, I don't know, they're not qualified. They'll tell you they're not really qualified to give medical diagnosis or prognosis. So usually I see that they rely upon what medical professionals have said or indicated or what they've seen in their experience. But if you get these folks on the exam that are like a social worker or someone who does not have medical experience, they can't really give an expert opinion on medical diagnosis, prognosis, and recommended course of treatment. Now they can give what they observe as far as incapacity and capacity and make recommendations, but I think sometimes they tend to not be qualified and bleed over into the medical prognosis, diagnosis, and recommended course of treatment. The report must include an evaluation of the alleged incapacitated person's ability to retain his or her rights, including without limitation the right to marry, vote, contract, manage, dispose of property, driver's license, etc. The results of the comprehensive examination and the committee members' assessment of information provided by the attendant or family physician, if any. Again, that goes back to that they're supposed to be checking in with the family physician or general physician in these cases. And then 4, a description of any matters with respect to which the person lacks the capacity to exercise rights, the extent of that incapacity, and the factual basis for the determination that the person lacks that capacity. So there you have what a report should have, and oftentimes they do have all these things. Oh, and there's 2 more, but sometimes I think there's a lot of those that I just listed that are missing. These 2 that are listed here are there, the names of the person present during the time the committee member conducted his or examination, and the signature of the committee member. The case I mentioned to you before we're going to look at, which I think gives you some good insight on what the courts expect with a comprehensive examination, is the case of Cook v. Cook. It's a 4th DCA case out of 2018. I don't know how much we can really get into it today, but I just want to give you quick facts about it and keep it in mind as a good source to look back if you're trying to determine, you've got an examining report and you want to see if it complies with the minimum requirements of a comprehensive examination. In this case, Mr. Cook, his brothers brought a petition. He was a recluse, not going out, not really keeping good hygiene. They had some safety concerns of the way he was conducted at his house, with hoarding and stuff. And he seemed to be having some mental decline. So that was the facts. Now, ultimately, there were some examining committee reports that came out, and the court found that they fell so short of the standard of comprehensive. I think at least one of them, there was no in-person physical exam. One was just relying upon what was in another medical report, things like that. And the court emphasized that the statute has these these things about functional assessment, physical, mental, all that has to be addressed. Simply just showing up or going on a Zoom, observing for 5 minutes probably doesn't make for a comprehensive exam. That term is used, and the court emphasized the examination has to be comprehensive. Now, we all know, if we practice in this area, many of these examiners, you're lucky if they spend 15 minutes. Make note of that, because I think the time that they were there can be used later to argue whether that was really enough time to have a comprehensive examination on those 3 essential elements that we looked at before that's mandated by the statute: physical, mental, and functional assessment. So the Cook Court, one of the key quotes there is, a prospective ward deserves a thorough mental health examination to determine whether his condition is curable or treatable. The court highlights that all aspects of the comprehensive examinations are essential elements in a capacity decision and must be conducted or explained if omitted. So this was one of those cases where there was just too many omissions in the report. The time spent was very lax. Given the court any really meaningful information from their reports, it was just lacking. There was nothing really contained in the reports that the court couldn't have already obtained from reading the previous medical doctor's reports. It didn't really give a fair and reasonable assessment of what they observed as it related to medical, mental, and functional assessment. That's what the court's looking for. And that takes a little bit of time. I would argue that's very hard to do in 15 minutes unless you have someone who's just non-functioning at all. But in this case, I don't know Mr. Cook, but we can almost imagine him. He's probably someone who's a little, become a little eccentric in his older age. May not be due to mental illness. It may or mental decline. It may just be a choice. It may just be, you can be a recluse, you can be odd, you can decide not to bathe yourself as much as the rest of us. Those kind of things don't necessarily equal incapacity. They may be symptoms of incapacity, and I think that's what you saw here. And then you saw people that just went and saw him and just described, very little about actually what was going on and what what a fair assessment was from the circumstances. Instead, was just, regurgitating other reports about his medical situation. So again, if you have a report and you have concerns about whether it's comprehensive, take a look at this case and compare and see if you think it matches up. Because the court in that situation had some pretty strong language about we're not going to take rights away from people without having the requisite amount of information that the statute requires. Okay, just some finishing up on procedure here on that same statute, subsection H. Within 3 days after receipt of each examining committee member's report, the clerk shall serve the report on the petitioner and the attorney for the AIP by electronic mail delivery, etc. And must the petitioner and the attorney for the alleged incapacitated person must be served with all reports at least 10 days before the hearing on the petition, unless the reports are not complete, in which case the petitioner and attorney for the AIP may waive the 10-day requirement and consent to the consideration of the report by the court at the adjudicatory hearing. If such service is not timely effectuated, the petitioner or the AIP may move for a continuance of the hearing. The petitioner, and subsection I there, the petitioner and the alleged incapacitated person may object to the introduction into evidence of all or any portion of the examining committee members' reports by filing and serving a written objection on the either party no later than 5 days before the adjudicatory hearing. The objection must state the basis upon which the challenge of admissibility is made. If an objection is timely filed and served, the court shall apply the rules of evidence in determining the report's admissibility. For good cause shown, the court may extend the time to file and serve the written objections. Now, this is important because, a few years back, people figured out they were just letting in these reports as a matter of course, but they contain hearsay. And then a ruling came out, yeah, you're right. There's no exception to the hearsay rule per se about these reports. So if you don't have your committee member there, your reports aren't coming in if someone's not going to waive the hearsay rule. So this essentially now it requires you to put the parties on notice if you plan to assert hearsay or any other reason why you think the reports are not admissible. Again, this relates to admissibility. Does that now should you include as to substance? I think so. If you're saying that it's not comprehensive or you think it doesn't comply with the statutes and you're going to essentially ask the court to disregard it or strike it, I think that I would put it in my objections, even though it's not terribly clear there if they're wanting substantive objection as well, not just procedurally admissibility objections. But I think if you're going to make any arguments about how much weight the judge should give it, I would put that in there too, even if it doesn't maybe per se make it inadmissible, just to avoid any claims that there's a surprise at the end. Now we've gone through that, and as you've seen, there's been a lot of deadlines I've listed, pretty quick deadlines. Within 3 days, the court will do this. The most important, the examining committee will examine and file their report within 15 days, things like that. If you practice in this area, while the courts have become really good at getting their orders out and examining appointments pretty quick and pretty timely, the examining committee again being overburdened in a lot of cases, and this not being their primary concern, and most of them are doing this in part as a public service, not because they're compensated so well. All those reasons, they're not always timely on their reports and things like that, and it can play havoc with trying to schedule things, because a lot of these things, as we just read that last one, they must be served. The reports must be served at least 10 days before the hearing. And sometimes you have someone you've already set the hearing and the report's not filed, and you have to make this choice. Do you ask for a continuance of the hearing? Oftentimes, that's not advisable from either side. Maybe the person being alleged incapacitated wants to get this over with, and maybe the other side has safety concerns about the person that's an AIP. And so you don't want to keep continuing it. So then you're put in a position that you can waive it. And so that can That is the reality of these deadlines. Are they set forth in the statute? Should they be complied with? Yes. Is the reality that sometimes you have to waive them because just the practicality of getting the reports done, getting the examinations done? That's true also. 744.331 subsection 3I, the petitioner and the AIP both have standing to object to introduction of any report by filing and serving the written objections on other parties. No later, that should be 10 days before the hearing. I'm sorry, 5 days before the hearing on incapacity. That's probably your best way to raise a timeliness argument that I haven't had sufficient time, and therefore those reports should not be entered. But just be aware that the court will likely just grant a continuance or try to push it out for a few days. So you get your three. Now we're in the part of the procedure. You've received 3 reports back. First, take a look at them. If 2 out of the 3 concludes that the AIP is capacitated, the court has to dismiss the petition. And I mean completely capacitated, even if, it saves the issue if there's even a partial incapacity or limited finding. But if 2 out of 3 are complete, the court shall dismiss the petition. Now keep that in mind, because later we're going to talk about some procedures and, well, what if the court's basing that on what you think are bad reports, and when should you bring that to the court's attention before or after the court enters a dismissal. We're going to get a little bit more into that as we talk about some of the motion practice and the procedures that are involved in these type of things when you're contesting examination committee reports. 744.331 subsection 5. We've got the adjudicatory hearing. This is the evidentiary hearing where the judge is going to take in evidence, including the reports, and make a determination of capacity. We've got some deadlines here. We've got, the court shall set the date upon the petition will be heard. Once the examining committee is appointed, the adjudicatory hearing must be conducted at least 10 days, but no more than 30 days after the filing of the last filed report, unless good cause is shown. Again, those dates aren't set when the examining committee is appointed at all times. The court has their own procedures. You have to find hearing time. Then you have more parties involved, like the appointed counsel or maybe other counsel that's become involved. And you have witnesses, maybe if you're going to have a contested hearing. So if you have a contested evidentiary hearing, it's extremely rare to be able to comply with this short deadline. But that would be your good cause showing that you have evidence to put on that's going to require, the coordination with other parties and things like that. But be mindful, because as we'll look in, one of the strategies for attacking is timeliness on these things. If too much time passes, the reports become what's known as called stale. It's become a term used in guardianship law, and the court is more likely to disregard them as not being too close enough in time to his determination. So just be aware of that when you're setting your hearing. You don't want a date 3 months out, 4 months out. That could be problematic. And if you're going to set it out outside these guidelines, it's very advisable, for the record, especially, to have the parties either agree, all parties agree, including the AIP, to have it outside, or filing a motion, obtaining an order to finding good cause to have it outside these deadlines. That you'll find that handy if there's appeals and things later on. The alleged incapacitated person must be present at the hearing unless waived by the AIP or their attorney or for good cause. Now, obviously, good causes, they're in the hospital, they're complete, and they're in a coma, which I've had, or they've had a stroke and they have absolutely no awareness of where they are, and it would be almost cruel to will them in, to a proceeding like this. But that, again, that's between the AIP and their attorney. Now you do have to remember, and it probably doesn't say in this statute, but it's in other guardianship code procedures, the AIP cannot be compelled to testify. If they want to testify, they're certainly allowed to. and they're allowed to confront their, accuser, so to speak, the witnesses, giving testimony against them, but they cannot be compelled to testify in these proceedings. Subsection C here says in the adjudicatory hearing on a petition alleging incapacity, the partial or total incapacity of the person must be established by clear and convincing evidence. I want to underline clear and convincing evidence because I think some of these reports sometimes can be so, for lack of a better word, lacking detail and substance that I think that you can say there's some evidence, but clear and convincing, as we know, that's a step above just 51%. So remember, that's the standard, not by preponderance, clear and convincing, and sometimes you might want to bring that back and show that it's related to the reports. Or conversely, you may show that the reports are so good, done by people that certainly had the expertise, laid the foundation, and that is clear and convincing evidence, and much more clear and convincing than maybe someone's lay opinion, a relative's lay opinion, or something like that. So just backing up a little bit, who are these examining committee members other than what we already went through? Who can and cannot be served on the committee? I think we touched on these, and I'm going to tell you it's pretty much anybody in the court's sound discretion by the definition. But again, I think you need to look if it's not someone that was in the enlisted or the listed names here, the listed professions. Look at it and see if there might be an argument that the person lacks overall expertise, depending on their profession. And I mean, if they're really just a lay person, I mean, how can they, which I have seen some that I certainly, I think it's hard to say that they have expertise, especially by the standard that we use today for experts. I think we touched on the education requirements, and I gave you where some courses are available online. If you want to take a look at that, I think they're good to take a look at for attacking reports because you can see sometimes all these, this advice or these procedures they tell examining committee members they should follow in these education courses. You can go through and see that they didn't. For example, I don't know if I don't think I may have listed it and passed over or not, but there is a statute requirement that says the examining committee member must be able to communicate with the AIP during the exam in their native language. Now, and this is true even if they are completely bilingual and speak two languages very, very well. There's a fundamental reason for this. When people get older, or at least studies have shown when people get older, even though they speak a second language very well, let's say, for example, English is their second language and they're very fluent, as you get older and the natural course of aging, you start forgetting words or words. And the first ones you're going to forget are the second language that you learn, not the first. So sometimes they've found that when you ask people questions and they hesitate or they show confusion, it's not because they're confused per se, but for whatever reason, that word that they learned as a second language has dropped out of their memory. And if you asked it in their native language, they would be able to answer it much quicker and with much more assuredness. And so to avoid those kind of things, and obviously just to avoid general communication problems and make sure it's not miscommunication that's leading to opinions, it's good to confirm that there's someone who speaks the native language. Again, I see people say, well, it doesn't matter because they speak English, so to speak, very well, very fluently. That's not the issue. The issue is that it's a second language and that you're quicker to forget those words than you would be your native language. And we're trying to avoid that the results here from the examining committee that maybe just based on the person didn't understand your question or was unable to, to converse with you as quickly or as efficiently in the language you were choosing. And it really wasn't because they lacked capacity or, or functioning mentally and things like that, in decision making and judgment and stuff, the things that we're really concerned about incapacity. We're not concerned if you don't remember the English word for, apple. But we're more concerned about if you lack, good judgment or cognitive skills that would lead you to be put in a vulnerable or dangerous position. So, but the main things that you need to remember about the role of these examining committee members, and if they've stepped out of that, be ready to address it at any hearing, is they're supposed to have an impartial role. And that would seem pretty blatant. And I don't think anybody's usually appointed that's, or at least not, obviously if someone's reported that's a relative or used to be someone's doctor, you move to strike them or, and replace them. But impartial in the sense that I have seen, because they're speaking to the petitioner, the petitioner's attorney, or someone else, there becomes a friendliness that I think sometimes these committee members compromise at least the appearance of impartiality if they become very friendly or too friendly and or at least on the surface with certain parties as opposed to other parties. And you want to avoid that. You want to avoid even the appearance of having some kind of partiality even if it's not, not so. We all know as professionals, we can have cordial relationships with other professionals, but we never want to, we all have to be cognizant of if it may appear to a third party to be impartial. And then we went through the examination report requirements in pretty detail just now. And I've put some forms here. I'm just going to skip through them. Feel free to go back and look. But these are some of the examination forms that are basic. Most counties now have their own or circuits have some that they're pretty much the same. There will be some variations though. You'll see a little bit of variations. I think one of the key things on here is there's always going to be a part where it asks about the consultation with family physician, and there's going to be a part that asks about what's your recommendation on least restrictive means. And that's really funny because you just saw we went through the requirements and it didn't really talk about the examining committee even assessing at least restrictive means, but yet on the reports they're expected to give some kind of opinion on that. Which again, you might want to note that, well, they came to an opinion there is or not less restrictive means. Honestly, how would they even have the basis of knowledge? I mean, how would they know if there's a durable power of attorney? How would they know if there's, other things put in place unless someone gives them that? So again, that might be a foundation that you can attack later on in their reports. Did they actually have the foundation to even render that opinion? I want you to go through too these lists. They're so, they've become so just part of the minutiae. But if you really look at these, there can be it's so easy to have internal conflict. And because I see a lot that people will mark that they can't make contracts. Okay, they lack capacity, but then they'll say they have the capacity to make gifts or work a job, which I think an employment, that's in a contract, an employment contract. And if you can't bind yourself to a contract, it certainly begs the question then, but you have the capacity to make a decision whether you want to give your money away as opposed to entering into a business relationship with your money. I think sometimes when you see things like that, that may just strike you as, odd. It certainly gives you some fodder to ask the committee member what they were thinking in there. Why would you distinguish or choose? What is it that you saw or read or observed that made you distinguish those two things? Again, can't make a contract, but they can make a will. I see that sometimes, and that doesn't seem to be consistent. And quite, and then of course they choose whether they want plenary or limited, meaning that if the ward has some capacity and can do some things, then a limited is more appropriate. So these are some examples I gathered from different districts. And some assessment procedures that someone has came up with Florida Guardianships and thought these forms may be helpful. You can find most of these online with the various court districts that you practice in, or with the Elder Affairs and the State Guardianship Office have some of these things as well. I'll let you peruse those more at your leisure. Because now we're going to get into the attacking. And I think we've noticed some areas as we've gone along, as we've reviewed the procedures, looked at the statutes, you can start seeing it that there oftentimes are ways to attack. Or conversely, if you want the exam to be upheld, try to ensure that the exam complies with these certain procedures, or do follow up with the committee member to see if they can supplement or things like that. Whichever way you're trying, whether you're defending it or attacking it. So I think we've gone pretty good through the comprehension of the exam and report. You want, you know, little answers, a few words here and there, 15 minutes or less with a person, but yeah, they want to take all their legal rights away. That I think happens way too often, and I think it's real good fodder for attacking exams, especially when you look at what the statute says, and you look at cases like that Cook case, where the court is emphasizing that these reports are heavily, are supposed to be given heavy weight by the court, and you can't be making these determinations on the fly. So look at that. Look at how comprehensive was it. If you did talk to the family physician, why? Why wouldn't you talk to them? See when was the last time they were seen, and what were they like then? Or maybe the physician knows of certain quirks that they have that isn't really determinative of incapacity. It's just maybe they don't, there's just quirks of their understanding or their language abilities. Quality of the exam and report. I think I mentioned the language. Make sure that we don't have a language issue, that there may be miscommunications based on language. Make sure that your examining committee member, if you're looking to, the petitioner, you want to find incapacity, make sure they know what the first language is, and make sure that when they're point out to them that, are you their first language is, Portuguese. Do you speak Portuguese? Things like that. I think time and place, again, I think that goes to comprehension. I think anytime someone sits for 5 to 10 minutes or on Zoom, they're kind of opening themselves up to a time, whether they've had sufficient time and they did it in an appropriate place to tell the court they gave a comprehensive exam, and that their exam is, quality and really gives the court meaningful information, and not just a throwaway like the Cook court complained of. And now there's exceptions to this. Obviously, we have people that are going to be examined that were in a car accident and they're in a coma. I mean, that should only take 5 minutes or less. Things like that, or someone who's, been incubated and things like that. There's going to be certain things that just, you're not going to spend a lot of time with that person. There's going to be things that necessitates a Zoom examination, but anybody who does that as a matter of course, I think they're opening themselves up to having their reports attacked if it's a contested hearing. Look at the consistency of the reports. I think we just went through that. When you look through those things, it's easy to say yes and no, but when you really compare the two things, aren't they using the same function? Aren't they using the same mental function or judgment control? What is it that you think this one's okay, but this one isn't? I always laugh to myself. I see so many, they mark lack capacity for everything, but they say yes to voting. I mean, that could be sort of a judgment on what it takes, what mental capacity you need to vote. But again, or that they should be able to continue to drive. I always, laugh, but nervous laugh at that one. If they don't have, the good judgment to be able to do other things, why would you let them have a license and go on the road just because maybe they renewed their license a few years ago and passed the test? I would question, why is your report so internally inconsistent? What did you observe exactly or conclude exactly would make you think this one's okay, but this one isn't? You'd be surprised. Sometimes I think these things just get checked and they don't really give it as much thought, and it's a place to, essentially, attack credibility and things like this. Look, this is a good place for good fodder for attacking reports too. And if you're on the other side, you should be thinking about these things and making sure you firmed them up before the hearing. But that's on what I call limitations of the report, and we touched on that. People will opine, oh, they must have a plenary guardian. There's no least restrictive means possible. But then you ask them, well, do you know what their estate plan? Do you know if they have a durable power of attorney? Do you know if they have all these things in place? Do you know if they have a trustee who manages their property? And oftentimes they'll say, no, nobody gave me that. And, well, then you really didn't really have the foundation to come to that opinion, correct? You could only give so much information on that. I don't fault them for filling out the report and as they're required, but I think you have to qualify it that there may be, to my knowledge, I haven't been given those things. And I think you would see that a lot in these opinions, that when you really ask them, well, did you look at this? Someone told you they suffer from this, but did you, look at medical records to see if that's true and things like that. Look at it. Look at what they don't have. Point out that you saw them today, but you don't see them day to day. You saw them on a day that they were nervous and anxious and stressed, and you don't see them day to day. You don't see them on, every good day either. So they have to admit that one of the limitations of their report is it's just a moment in time. By definition, it's just a moment in time with this person. That also gets into the timeliness issue. And why I mentioned before that you really need to be aware of the time, even if everybody's waiving, statutorily saying, okay, we'll waive this, we'll have a hearing, 2 months later. Think about it. As time passes, those reports by definition are less useful because the judge has to make a determination of incapacity today. And all it takes is for you now to bring someone on the stand, a doctor or medical professional, to say, I recently examined them. And they are if that was the case when they did these reports, they're much improved today. And the law and the guardianship procedures don't really give you a mechanism to counter that. You can't subject the AIP to more exams, other than what's provided by the examining committee. You can't just say, well, we want to re-examine her now. That's not how the procedure works. So again, that's another reason to think about not letting things become stale. And that happened, if you want to look at it, there's a case out of the 4th DCA 2007, Graham versus Florida DCF 970 Southern 2nd 438, where the court said, yeah, I mean, if you have someone that comes after the examining committee testified that that's how she was on a certain day, or whoever the ward was in that case, I can't remember if it's a man or female. But now, a lot of time has passed. It was like 3 or 4 months. And we've got someone today who said whatever was maybe wrong with her that day, taking that at face value, today she's just fine. And you can get yourself in kind of a procedural snafu there because it's hard to counter that. Because you're not allowed to just keep subjecting the ward to examinations involuntarily, or the AIP. I also listed bias here. And I kind of touched on that before with getting personal. You'd be surprised if you subpoena communications or ask the examining committee member for communications they've had with certain parties. And you might be surprised to see how, I don't want to say unprofessional, but maybe how friendly the communications can get. Now, I'm not saying that necessarily means there was bias, but if you're talking to someone with a familiar term, in familiar terms, one of the parties who wants you to find incapacities, for example, and you can bring that out at the hearing, it goes to question their credibility, and maybe they didn't have a preconceived bias before they met with this person. Again, why I keep my conversations with examining committee members very to the point, no over friendliness, just because I don't want that appearance of impropriety. So now we're going to look at pitfalls to avoid, or preparations for the hearing if you want to boost up your reports there, and they're kind of the flip side of what we just talked about. Communications, and make sure those communications are nothing that when you take them out of context and put them in a hearing, it's going to look like your examining committee person and the petitioner or the petitioner's attorneys are now best friends, and they're talking about, yes, I love that vacation spot, or I love that restaurant. And then it starts to look like you're less impartial. And it doesn't mean that you are, but it's something to avoid. Make sure that the examining committee members, especially if you want to beef up their reports and you want the reports to be entered, make sure they have sufficient information to lay the foundation. For example, on the least restrictive means, share their estate plan if you know, or whatever you think the thing is, or have someone available to answer their questions. Make sure they have, the information and access to physicians and things like that. Make sure that, that you're not setting them up to fail, so to speak. When you preparing for a hearing and you have some reports that you have problems with, or problems you should look for, these are some areas I would tell you to look out for. Resolve any inconsistencies within a report or within multiple reports. if an examining committee member has made something that could be arguably inconsistent, talk to them about it and ask them, can you give me some clarification or can you supplement on that so we know we're prepared for hearing on what your thoughts are on that. Um, and then sometimes the reports themselves can be a little inconsistent, and it's always good to do a chart, especially when you have a lot of mixed bags, and to see if there's any areas where everybody agrees. What areas, that they may disagree with, and see if you can get a pattern, and you can essentially resolve, say, well, it's not as inconsistent as we think. People have much more problems with sort of the property, or bit financial aspects, but maybe not. They're all much more in agreement on the personal aspects of the person maintain capacity and control in those areas. So I think it's just good preparation to think through those things, think what questions the court's going to have himself on why this and why not this, and gives you the best chance for the court to give ultimate weight to those reports. Hearsay readiness, make sure you got your committee members there. If, and I would do that even if, they haven't filed objections. I would affirmatively, make sure that they are waiving the hearsay objections. I always send emails, say, didn't get any objections, presume you're waiving the hearsay, and I won't, I may not compel all the examining committee members or something like that for testimony, relying upon that. But if you got a contested matter, you're going to usually have your examining committee members there anyway. Cost, fees, who pays? Yeah, that's pretty, you would think it's pretty straightforward, and in some ways it is. It just seems unfair. If the person's determined incapacitated, then the fees and costs of the examining committee are paid by the guardian once they're appointed from the guardianship estate. Or if, there's the judge decides, least restrictive means, I think you can still have, probably an order from the trustee or power, the durable power attorney, the agent or whomever to pay it. If there's no incapacity determination, the state pays if there's eligible funds to pay the fee. The only time the petitioner would pay is if the court has to make a finding that their filing was made in good faith, completely frivolous, and that's rare. Unless somebody is really just, using guardianship as a weapon and for improper purposes. But I would think that the vast majority of these, someone has some reason to believe or some reason to be concerned that someone might be incapacitated. This is the section about fees and everything, and about the 90-day period, about filing your claim with the state, those kind of things. So you can go through that at 744.331 subsection 7 if you're interested in how they're getting paid and things like that. Really brief. I know we're only got about 6 or 7 minutes. So I want to get really quick into motion practice. There's, as a matter of law, more so than in the statute, there's various motions that I would recommend anybody to file if they're got a problem with examining committee reports, or at least have them in your arsenal to consider. And one is a motion to strike report, which isn't, I can't point you to a specific statute that tells you, that this is a motion to strike report, this is when it should be filed, and this is what it should contain. But it's more of a creature of law, and maybe just, an implied procedure. But if you're curious about it, look at the case Levine versus Levine. That came out in February 27, 2009 in the 5th TCA. I only have the Westlaw number. It's 482260. But in that one, the 5th TCA at least kind of created or highlighted a procedural snafu. Let's say you go through your evidentiary hearing. You've been able to show that the examining committee report was, didn't have maybe you did speak the first language. There's all kind of reasons why it probably should have not been considered. It didn't comply. It wasn't comprehensive. You have a whole litany, and maybe even the judge agrees with you. That's good and dandy, but there's one little procedure where that won't work now, and that's when if 2 reports come back and they say completely capacitated, because the court at that time before the hearing is supposed to dismiss. What you have to be ready to do in pretty quick order before you get that dismissal is file a motion to strike that report, saying, well, they only came to capacity because they didn't do a comprehensive exam or because of bias, whatever your reasons are. And you need to do it before the judge enters the order. Because if you don't, the 50CA has said then you've given up your right to appeal the order of dismissal. So be cognizant of that. Be cognizant of using it even if you're going to have a full hearing because you have mixed reports. Be cognizant of maybe a motion to strike the report as using it as a mechanism. If you do it during the proceedings, the court is likely and decides to strike it. He's likely just to ask another member to be appointed, or ask the member to go out and do another exam and beef up or supplement the report. You can do a motion to replace committee member. Again, I can't. There's some reference to it in the statutes. There's no form, under the rules or anything. But you can do this. I've done this where if something has happened where the AIP is uncomfortable with the committee member, like they showed up out of the blue, they were rude, they created something has been created that just starts it off on a bad foot and that may prejudice the examination. A quick motion and ask just for a replacement is a good avenue to go. Also remember you want to replace if the person can't speak their first language or that there's some reason to believe that they're biased because they have some kind of affiliation with one of the parties. That's another reason to use it. Appeals, remember the Levine kind of weird procedure rule that you don't have a right to appeal the order of dismissal in the case of two committee members finding incapacity unless you file a motion to strike before it's entered. Remember that snafu. Otherwise, incapacity orders are typically, appealable like other final orders within 30 days. So, we've got just a few minutes left. If there's any questions, now would be the time to put them in a chat. I do have my information up there. I appreciate your time today. I know we had to rush through some of these things, but I hope it invoked a thoughtful review, so to speak, of what really should be in the examination committee reports and how you as a litigator or advocate can use those rules and these procedures to your client's benefit in the future. If you have a question, you have a fun war story, what have you want to share, I welcome all comments and questions, especially from my fellow professionals. And you see my contact information there on the screen. Let me just see if we have any questions. I'm not seeing any come up on the chat. With that, then we're going to conclude for today. Thank you again for joining me and going through this discussion with me.